that we should not end up knowing the price of everything and the value of nothing. It is folly to try to measure the value of the administration of justice in terms of dollars and cents. Properly understood, it is essential to all else which is a part of a civilized and ordered society. Under the Constitution, the judiciary is a co-equal independent branch of government. This constitutional status must be reflected in the reality of the conduct of our operations, thereby strengthening the institutional independence of the judiciary. The judiciary must not be treated as another government department or agency. It bears reminding the public that it is an independent judiciary which is the ultimate custodian of your rights and liberties. If we are to fulfill our vital constitutional role, the judiciary must be given adequate financial resources, competent staff, proper equipment and supplies, and suitable physical premises to operate the courts. The judiciary needs to have more control over its administrative, financial, and operational matters in order to implement the necessary reforms within the court system. It is for this reason that I am disappointed that the Court Services Bill has not been passed into law. It was tabled in the House of Assembly last year, but was not advanced prior to the dissolution of Parliament. I am in communication with the Attorney General on this subject, and I am encouraged by his assurance that this matter will receive the urgent attention of the new administration. I strongly urge the government to reintroduce the Court Services Bill in the House of Assembly and expedite its passage and enactment into law. The bill, if passed, would be a transformative legislative intervention which would fundamentally change the operations of the courts. It was Lord Bryce who observed, I quote, "There is no better test of the excellence of a government than the efficiency of its judicial system." Close quote. We in the judiciary stand ready to do our part in improving efficiencies and productivity if we are provided with the means to do so. In reviewing the year of 2021 for the courts, I am reminded of the iconic opening words penned by Charles Dickens in A Tale of Two Cities. It was the best of times, it was the worst of times. For the judiciary, it was a year of innovation, reform, and significant progress in modernizing important components of the court system at a time where there was minimal resistance from stakeholders, mindful of the imperative to change in order to conduct business during the pandemic. In this sense, it was the best of times. On the other hand, the devastation and intrusion of COVID-19 into almost all human behavior was, in a sense, the worst of times. Throughout it all, the takeaway message is that 2021 was a productive year for the courts. However, there is still much more work to be done in 2022. And going forward, we will be focused on the execution and implementation of the many projects and initiatives which we've been working on for the past 2 years. The long-awaited case management system in the courts, known as JWorks, has now been installed, and the configuration and migration of the data will be completed before the end of this month. The go-live dates for the various divisions of the court will start in February. JWorks will be installed across the court system, including the magistrates' courts, the Supreme Court, and the Court of Appeal. The migration of the Court of Appeal data into JWorks will start later this month. The e-filing portal has been activated, and we are only waiting for the integration with the government payment system to be completed before launching this service. Lawyers and litigants should be e-filing documents by the end of this month. This will substantially change the function and role of the civil registry, and I will be saying more about this in the coming months. During 2021, we digitized in the courts approximately 3.2 million pages of court records, and these scanned documents will be ingested into JWorks over the next few weeks. Another 4.5 million pages of court records will be digitized between January and the end of July of this year. The newly renovated office for our digitization unit is expected to be completed by the end of this month. I wish to acknowledge the ongoing work of our small internal digitization unit headed by Mrs. Grace Boswick, who have performed under difficult circumstances. The digital recording system is ready to be implemented in the criminal division of the Supreme Court and the magistrates' courts, and has already been activated in a pilot program. The system will go live across the courts as soon as we complete the training of judicial staff and finalize the new policy and procedures manual. The bail management system has been launched and is operational. Effective the 7th of March 2022, all bail applications in the Supreme Court will have to be made through the new bail management system, thereby fully automating this process. Members of the criminal bar should take note of this date. The version of the bail management software for the magistrates' court has been completed and delivered to the judiciary, and it will be launched in February. The court automated payment system in the family magistrates' courts is operational, and we are now working on increasing utilization through training and the launch of a public awareness program. This will greatly simplify the process of making payments and receiving funds under orders from the family courts in the magistrates' court. We have automated the process for obtaining court hearing dates, and in most cases, dates are now given within 14 days of submitting the request. In interlocutory applications, we are aiming to hear all of these applications within 3 months. In the Supreme Court Criminal Division, we continue to have difficulties with fixing trial dates within reasonable time periods. Lawyers who practice in this area are accustomed to obtaining trial dates which are far into the future, based on their calendar. Every case must be considered on its own facts and circumstances. But as a general point, the court will not surrender its calendar to the commitments of counsel. It is time that we address the problem of scheduling conflicts and adjournments. Lawyers who are booked for 18 to 24 months into the future should not assume that this will dictate the pace of the case or the fixing of the trial date. I am aware that constitutional issues are engaged in this discussion, but the court is not impotent in the face of counsel who claim to have no availability for 2 or 3 years. I intend to discuss this matter with members of Bar Council, the Director of Public Prosecutions, and members of the criminal bar in an attempt to find a sensible and balanced approach to this problem. But the current position is no longer sustainable. We have a duty to the public to address the backlog and to get criminal cases to trial within a reasonable period of time. We will be setting up in the Registrar's Office a resolution desk, which will deal with all inquiries relating to procedural anomalies and cases where the targeted dates for action are not met. We in the court system must be accountable for our commitments with regard to workflows, and where we are not meeting our self-imposed deadlines, the matter can be referred to the resolution desk for early intervention. It is necessary for the court on the civil and family side to better triage cases at the intake stage to more efficiently direct their course through the court system. We will make this intervention through case progression officers who will proactively manage the life cycle of cases assigned to them using the new case management system. I will be issuing a practice direction in February, establishing motion days for hearing interlocutory applications which are not expected to take more than 30 to 60 minutes. The motion judge will also hear applications which do not qualify as urgent for the urgent duty judge, but which nonetheless justify an expedited hearing. The time is over where lawyers and litigants must wait months for hearing dates for non-contentious applications or applications which are procedural or case management related. There will be an increased use of paper applications in the Supreme Court, where the matter will be disposed of on the papers without a hearing. I also intend to increase the utilization of telephone hearings for appropriate applications. I will be releasing a practice direction setting out the details relating to these applications. When there are hearings, counsel will be expected to comply with time limits set by the presiding judicial officer for oral submissions. There simply is not enough judicial time to listen to counsel for as long as he or she wants to talk. Careful, thorough, clear, and reasoned written submissions by counsel will reduce the need for long oral submissions. We will, in 2022, continue to rely heavily on remote video Zoom court hearings in the Supreme Court. There have been many inquiries about the use of these hearings going forward. It is my view that remote video hearings in the Supreme Court are here to stay and are now a permanent part of the court system and will be used as one of the disposition modes, in addition to in-person hearings, telephone hearings, and applications on the papers. I am in discussion with the Attorney General with regard to conducting remote court hearings in the Family Islands, using courtrooms where available, and the office of the administrator where there is no courtroom. There is no good reason why we cannot deliver greater access to justice for persons in the Family Islands, where they will not have to incur the costs and endure the inconvenience of traveling to either Grand Bahama or New Providence to deal with their cases. The solution will involve the deployment of the necessary technology and a package of legislative amendments to facilitate the process. Once the necessary legislative amendments are made, we will be able to conduct hearings in the Family Islands between the visits of the magistrates on circuit. This will provide much greater access to justice and to the courts for persons outside of New Providence and Grand Bahama. I have also had discussions with the Attorney General relating to the proposed amendment of the Magistrates Act to increase the civil jurisdiction of the magistrates to $20,000 and to award costs up to $1,000. This will be a part of a compendium of legislation relating to the administration of justice, which I have discussed with the Attorney General. This will include proposed amendments to the Evidence Act, the Criminal Procedure Code, the Jurors Act, the Child Protection Act as it pertains to the Juvenile Court, and the Coroners Act. I was very pleased to hear the Attorney General state in his address to the court that he is committed to